Swayam Prabha. Digital India. Educated India.
Nelson Mandela, the leader who fought apartheid in South Africa, and someone who fought for rights and equality, once stated that as long as poverty, injustice, and inequality persist in the world, I repeat, as long as poverty, injustice, and inequality exist in the world, none of us can truly rest in peace. So I think poverty, injustice, and inequality is the concern for unrest across the world. And when we talk of inequality, it could be inequality which is social or economical in character and nature. And I think it is only fair for human beings in society to expect that the population is treated fairly and without any bias by the government. And I think it's important that the Constitution not only speaks and ensures equality, but also tries to promote the theories of equality along with equity. Now, there is a very important distinction between equality and equity. Equality is the principle where everyone, irrespective of whatever background, income, or wealth or power you have, shall have the right to be treated equally before the law and are entitled to the equal protection of the law. Equity, on the other hand, would demand that suppose there is an elder, how much of food an elder should get and how much of food a minor should get or a child should get. Now, elders may have more appetites, the government must provide more. A child may want lesser appetite. Now, this does not mean that the child and the adult should be treated equally, especially vis-a-vis government schemes and so on and so forth. So, equity would demand that, look, it depends upon your need, depends upon your abilities or the circumstances surrounding you. You will be treated fairly based on your needs and your circumstances. So equity would demand that, look, sometimes you would need special protection for children, which probably adults are not required. So both of these two components are interwoven in the Constitution of India. Now, some of the important cases that one would just want to reflect upon under Article 14 of the Constitution, which talks about equality before the law and equal protection of the law, is one, the Keshananda Bharati versus State of Kerala case. Of course, this is the basic structured doctrine case, and this Navtej Singh Johar versus the Union of India. It's a 2018 case. Now, in Navtej Singh Johar, this is a recent case that looked at Section 377 of the Indian Penal Code. Indian Penal Code is an 1860 legislation, and it was made by the Britishers at that point of time. And they, whatever they thought right, they did it. And please note, the Indian Penal Code continued to exist even post-independence. It is a great code. However, what was taken in Navtej Singh was the issue on the right of homosexuality or homosexuals, as the case may be. As we record these lectures, there is a pending matter before the Supreme Court of India on recognition of marriages among homosexuals. I'm sure by the time the course comes to being offered, this may be a judgment from the Supreme Court. However, in Navtej Singh, the issue was on whether consensual sex among adults between the same sex should be treated as unnatural sex under Section 377 of the Indian Penal Code. This was the real issue in this case. And hence the court said that right to equality means the LGBTQ plus community has the right to be treated fairly and equally as any other people or persons in a given society. So just because you are an LGBT, you cannot be discriminated against, and there cannot be a law that punishes you for consensual adult kind of relationships. And hence, the court in this case said that Section 377 of the Indian Penal Code, which applies to LGBTQ plus community, please note, it's not that Section 377 is entirely redundant right now because it still deals with unnatural sex. But should unnatural sex also include consensual adult homosexuality? That was the question in Navtej Singh Johar case that the Supreme Court had to answer. And the Supreme Court said that if the LGBTQ community is punished under Section 377, this would breach the right to equality. So I believe that, to some extent today, the challenges of modern day application of the right to equality are quite interesting, considering the, two sides of the story in terms of one, what we call as conservatism, which is kind of antithesis to what we call as liberalism. So there is a constitutional challenge on balancing both uh, uh, the extreme sides of the society, which could be a generational gap, it could be a gap of thoughts and ideologies, it could be a kind of a social transformation that is being sought in the constitution on the grounds and on the basis of equality. Please note, it is the duty of governments under Article 14 to eliminate disparities that exist in our society. The disparities would be based on, say, some social convention. Some of these disparities could be based on long-standing customs, like, say, untouchability or race discrimination. So, race discrimination actually hits the rule of equality quite deeply. And race discrimination, unfortunately, still in some pockets of the country may exist where the rule of equality will have to be followed. And hence, the rule of equality, friends, is actually a natural law theory. It's a theory that, every individual expects fair and equal treatment without any kind of discrimination from everyone in the society, but more pertinently and more prominently from the state. So, be it the farmers in India, be it the street vendors in India, be it the women in India, I think every person should enjoy his rights and liberties guaranteed to them with equality status that is granted and guaranteed by the Constitution of India. So, I think Article 14 does speak about social discrimination. It also talks about economic discrimination. So, it is the socio-economic upliftment of the citizens that is attempted by the protection guaranteed under Article 14. However, at this point of time, it may be pertinent and important to deal with the exceptions to equality. Now, before we go to the exceptions of equality, it is normally and very popularly stated that Article 14 also deals with what we call as the rule of law. The rule of law is a very, very important component of good governance. Rule of law is actually the most important pillar in which we say that, look, only the law will prevail and not the men who administer the law. It is the rule of law and not rule by men. A very popular jurist by name A.V. Dicey, he was a British jurist, he brought in the element of rule of law while he was trying to look at issues on equality. And he said that there are three elements of the rule of law. First, that rule of law assumes absence of arbitrary power. Arbitrariness is a very important issue in terms of the principles of equality. If you exercise your power in an arbitrary manner, arbitrariness means a process where you don't apply the principle of objectivity. You are quite subjective. You tend to choose one over the other just because it is your will and wish. So A.B. Dicey says any exercise of arbitrary power shall be punished by law, and it shall be something that should be taken quite seriously by law. And arbitrariness actually affects the rule of equality. It is against the rule of law. Second, he says that it is important that everyone should be treated equally before the law, be it citizens or non-citizens, be it officials or non-officials, it is poor or the rich, it is high or low. I think everyone is subject to the law of the land. So the law of the land shall apply to everyone equally. That is very, very important. Of course, we will speak about the exceptions when such kind of privileges or immunities can be granted. But please note, any such privilege or immunity should also be granted by law and not by men. And third and most importantly, friends, the rule of law principle says that the rights of individuals under the Constitution shall be defined and enforced by the courts of law. So the courts of law have the duty and obligation to implement rule of law. The courts of law are the ones who are going to be the custodian of the fundamental rights. They are the ones who shall protect and also provide remedies for the infringement of the rights. So you will notice that the Supreme Court of India time to time has held that Article 14 is the basis of rule of law in India. And this is the basic feature of the Constitution. And to any extent, Article 14 cannot probably be changed, like it was held in the Keshananda Bharati case, that there is something called the basic structure of the Constitution that cannot be amended, and right to equality is probably one of the basic features of the Constitution and cannot be subject to any kind of an amendment. So, what then are a few exceptions to the rule of law and the rule of equality? Friends, just to take an instance or example on the exceptions, you will notice that if you read Article 361, the President of India and the Governor of States enjoy certain kinds of immunities. We know that the President and the Governor of the states are the chief executive officers of their respective governments. The President of India is the chief executive of the central government. The Governor of any state is the chief executive of the state government. Now, as being the first citizens, as they are called, of the state and their respective governments, the President and the governors have been granted with certain kind of privileges and immunities. Please note, these kinds of privileges or immunities are also granted to certain sections in the community, like members of parliament, members of legislative assembly, that they cannot be arrested during the parliamentary sessions or when the sessions of the assembly are taking place. So, what are these privileges of immunity? Some examples of those privileges of immunity are that when the president and the governor are in office, which means they are not departed from their tenure, they are not former presidents or governors, they are still in office, they shall not be answerable in any court of law in the exercise and performance of their powers and duties in office. If it's a personal matter, of course, they will be answerable, but in their official capacity, if they're performing any duties, any functions, then they shall not be answerable in any court of law. Second, there shall not be any criminal proceeding against the president or the governor in any court during the term of their respective offices. There shall not be any process of arrest or imprisonment of the president or the governor during the tenure of their office, and no civil proceedings also shall not be instituted during the term of the president and the governor. So you will notice that these are certain privileges that are granted to the president and the governor, and Article 361A also says that no person shall be liable for any civil or criminal proceedings in any court in respect of publication in a newspaper or by radio or television of a substantially true report of any proceedings of either House of the Parliament or the House of Legislature of the state. So 361 is a privilege and immunity granted to the press people for fairly true reporting of what is happening in the House of Parliament or the House of Legislature. If you go to section Article 105, no member of the Parliament shall be liable. This is for a member of Parliament in any court. They shall not be liable for anything that was done by the member of Parliament or by any member during any parliamentary committees. So they shall not be liable for any of these proceedings before a court of law. Article 194 is the same privilege that is granted to MPs that are granted to the member of Legislative Assembly. So these are certain kinds of exceptions that are there, and you will notice that Sometimes there could be certain legislations that can be kept out of judicial review, and they cannot be challenged in the court of law, as they will be violating Article 14, right to equality. So when Article 31C was created as an exception to Article 14, I think the Supreme Court agreed that sometimes you should allow certain exceptions in the case of land reform movement, in the case of change of right to property, and certain legislations may not be able to guarantee those rights as well. Of course, you will notice that United Nations agencies, diplomatic missions of different other governments also are granted with certain diplomatic immunities as per international law. Sovereign, territories that exist in India, or sovereigns of different other countries. It may be a ruler, it may be a king, it could be an ambassador, it could be a diplomat. All of these also enjoy immunity from criminal and civil proceedings in the country. So these are certain examples of where you will find exception to the rule of equality as privileges and immunities are granted. So these could be considered to be certain kinds of privileged class of individuals who are not going to be treated as the same as a normal Indian citizen would be treated in terms of criminal or civil proceedings, as the case may be. So these are necessities that are created by international conventions at times. These are necessities to protect the dignity of the office of the president or the governor or the members of parliament or members of legislative assembly, so that it is something that is not being misused by opposition parties. So I think constitutionalism on the growth of these kinds of exceptions have come into existence, and the courts have upheld those kinds of exceptions as well.